Good evening, this is John Milburn for Laws 19038, Planning and Environment Law. This is week 5, and this week we're dealing with statutory instruments, regulatory tools, and the very important concept of ecologically sustainable development. Tonight we'll be talking some theory, we'll also be providing you some practical tips, and as always, access to information online that will assist you in terms of dealing with planning and environment law. So statutory instruments represent a form of delegated legislation. Legislation created by Parliament to give councils and other bodies the power to make laws that they otherwise wouldn't have power to do. And statutory instruments, regulatory tools, are very important in the concept of planning and environment law as ways in which up-to-date information is provided through the delegated legislation regime. And again, if we have any comments or questions from people online, please feel free to use the chat facility, or if you wish, simply unmute your microphone and ask a question. So great to have you on board. Okay, so we're talking about statutory instruments. One of the important things that we need to do, and I'll do this briefly, is talk about the way in which lawyers interpret statutes. There are a few different approaches to this, and one of them is what we call the literal approach. In other words, we take what the word says and we literally apply it. Lawyers love that because it means that we're able to look for loopholes in the wording. And I'll give you an example. If legislation said it's an offence to speed up to a certain figure, say 80 kilometres per hour, and designates a penalty, $100, and then says it's a penalty, it's an offence to speed over 80 kilometres per hour, the penalty is $200. But what that does is leave a situation where if someone is charged with speeding at 80 kilometres per hour, it's neither it's neither up to 80 and it's not over 80, it's exactly 80. There's no provision that says that that's a penalty. So it's a loophole, and we use that loophole to try and argue. However, that literal approach is sometimes overtaken by what we call the golden rule, which means that if the reading of a statute leads to an absurd result, the court would modify the literal meaning to remove or avoid that absurdity. Now, another thing that we do is consider the context of the word in a particular statute. So under that contextual approach, let me take this example. Say a spectator at a tennis match. Spectators are prohibited from taking glasses into the seating area. Well, in that context, we're not talking about spectacles, we're talking about glasses of beer, etc. And we work out what is meant by glasses, the word glasses, in the context of the way in which it's included in the sentence and why it's there. So we call that the contextual approach. Another one is the purposive approach, and that's where it's very important to consider the Acts Interpretation Act. There's a Commonwealth version of the Acts Interpretation Act. That's from 1901. That'll be relevant if you're considering a word under, say, the Environment Protection and Biodiversity Conservation Act. There's also a state version in Queensland from 1954, and you might consider that in the context of, say, interpreting a word which is not otherwise defined in, say, the Sustainable Planning Act. Now, apart from that, lawyers consider common law presumptions, and we also consider statutory rules. Now, we talked about common law last week in the context of the way in which judges interpret decisions that have come about in the past. But there are some common law presumptions. For example, one is words have their current meaning, or words have their technical meaning, or things that are included, things not included are excluded. And this is a really important one. Later provisions override earlier provisions. So if you have a later law, it is presumed to override and effectively automatically repeal, to the extent of any inconsistency, the earlier law on the same topic. So sometimes you'll see that a particular piece of legislation is not specifically repealed, but it's inconsistent with later piece of legislation Common law says we look at the later piece of legislation and it is deemed to automatically repeal the earlier one. So they're some of the basic rules that we apply when we're interpreting statutes. Now, when it comes to planning and environment law, we really need to know council guidelines, bylaws, regulations, things of that nature. It's a really important part of the way in which planning and environment law works. In other words, the statutes provide the big picture, and Parliament delegates to, say, councils the ability to make rules, regulations, bylaws, ordinances, things of that nature. So that's all part of this delegated legislation. What I want to do now is talk to you about the way in which this works for environmental legislation. Now, bear in mind, of course, that in environmental legislation we have the federal and we have the state. And the most important piece of legislation federally, of course, as I'm sure you know by now, is the Environment Protection and Biodiversity Conservation Act of 1999, or as we call it, the EPBCA. In Queensland, it's the Sustainable Planning Act 2009, but of course you probably read that that's about to be overtaken, repealed in favour of the Planning Act, which will become 2016. But for the moment, it's the Sustainable Planning Act. Okay, so they're the most important pieces of planning and environment legislation in the Commonwealth and Queensland sphere. There are other pieces of legislation. When you think in terms of Queensland, the Environmental Protection Act is extremely important, and other pieces of legislation such as the Vegetation Management Act are also very important. Okay, so when it comes to looking at legislation, it's important that you get a feel for how you get round the pieces of legislation. Where do you go? What's the starting point? I would suggest that if you're trying to understand a piece of legislation, have a look at the stated objects of the legislation. It's really important, not only as a way of understanding it, but also, look, if you're struggling to mount an argument in support of a certain proposition, it's always good to go back to the stated objects of the legislation and see if you can argue from that sort of really basic principle that your case is correct. And I guess that's the lawyer in me coming out. What we also do is we look at the explanatory memorandum, or sometimes we even look at Hansard. And I've got a YouTube video, which I think is at the tail end of week 1 in your notes on Moodle, on how to access Hansard if you're ever wondering how you do that. And Hansard, of course, is the record of the arguments that took place in Parliament prior to the introduction of legislation. Okay, so again, if you have any questions or comments, please let me know. Okay, so when you're looking at a statute, piece of legislation, think about the objects, look at the objects, and get a feel for it. Now, sometimes the objects actually impose an obligation upon administrative decision makers to pursue or fulfil an objective. For example, in the Environmental Protection Act state, that's Queensland, we'll see if we can find it. I'll have to share the screen, and I'll do that now. So hopefully you can see Austerlitz, which I guess is my go-to place when it comes to legislation. Let's have a look at Queensland, and we'll go to the... My internet is so slow tonight, it's painful. It's probably because I've got 101 functions happening at the one time. Got time to go and make a cup of tea and come back. All right, so Queensland, we'll look at the Environmental Protection Act, and eventually broadband cannot come early enough. We'll have a look at section 5, which deals with the object. And the reason I wanted to show you this is it's a bit different to an ordinary object, which is more a statement of general principle. In this one, as you'll see, it actually imposes an obligation on decision makers. And you might want to use that when it comes to mounting an argument. So we'll look at section 5, and it says, if under this act a functional power is conferred on a person, that is the administrative decision maker, the person must perform the function or exercise the power in the way that best achieves the object of this act. So it's not have regard to, it's must perform. So sometimes, as in this case, the object imposes specific obligations. All right, so we've talked last week about delegated legislation. We talked about subordinate legislation, if you like. There's different words for it. And essentially that's where Parliament gives power to make subordinate legislation to councils. They do that for a number of reasons: to save time in Parliament, because the legislation is very technical or detailed, too much for parliamentary consideration, or maybe to deal with rapidly changing situations, or to allow for quick action in the case of an emergency. So there's a whole lot of reasons why we have this delegated legislation. But rather than just talk about it, let's see if we can actually show you some examples, and importantly, show you how to find this delegated legislation. Now, we'll start with the Commonlaw sphere, and you'll see here that I have a really important homepage as a web page. It's the Federal Register of Legislation. So if you want the authoritative way to find legislation, you look in Acts, and that's kind of like Ostly, but this is the authorised version. Now, the part that I want to show you tonight is this here, legislative instruments in force, and you'll see that there's a link on the left-hand side of the page as well. If we click on that link, and again, it's going to take forever, I suspect, but if we click on that link, we're now going into this delegated legislation, or as we call it, statutory instruments. And it's getting there eventually, I think. So statutory instruments, legislative instruments, subordinate legislation, all much the same thing for different terms. I apologise for the slowness of this internet. We'll get there eventually. All right, so what this does is bring up an access point. Let's go to EN for environment. And what you'll see here is lots of pieces of legislative instruments that relate to the environment. Unsurprisingly, given that we've gone to EN. Now, I know from having been here that what I want to show you is on the second page, because it's one of the most important pieces of delegated legislation, which is in relation to the regulations. So when you're dealing with an act, you might also consider the regulations, and that gives some teeth to the legislation. It provides for some detail, and for all those reasons I mentioned before, it's much easier to incorporate things that change rapidly, more procedural things, into the regulations than try to label with that in the Act itself. So on the second page, I know that there is the provision for the Environment Protection and Biodiversity Conservation Regulations. And if this takes any longer, you might just have to take my word on it. It's about halfway down the page. And the reason I'm showing you this is that if you come across some commentary in relation to, say, regulations, now you'll know how to access those regulations and look for yourself at the legislation, at the delegated legislation through the regulation. If there are any questions, please let me know. All right, well, I'm going to abandon that, but trust me, it's there, the regulations. Now, at a state level, what we do is have a look at the Queensland Legislation Handbook. This is a great resource, and you'll see this through the Department of Premier and Cabinet webpage. The handbook provides lots of interesting information, and down here, 6.1, it has a commentary in relation to subordinate legislation with a really good, simple explanation of what subordinate legislation is and why it's important. And it's very important that you bear in mind, of course, that these things work in a hierarchy. So legislation is more important than delegated legislation, etc., etc. Okay, so trust me that the commentary in relation to what is subordinate legislation is very good. and I might abandon that for the moment. I'll stop the share. If that page does come up, I'll let you know, but it's taking too long. All right, so tonight I wanted to show you something about legislation, and importantly, I wanted to introduce a very important environmental concept, which is ecologically sustainable development. It's really a cornerstone when we're talking about environmental principles, but of course it has a great application in planning and environment law as well, so that decisions made by government through councils, administratively at the executive level, and then even the courts are all guided by these general principles. So let's have a look at the Queensland situation, and I'm just going to Consolidated Acts. I'll share the screen again, because what I want to do is show you, in fact what I might do is go to the Commonwealth first, and I'll share the screen. And what we're going to do is have a look at ecologically sustainable development. And hopefully you can see now AustLII. We go to the Commonwealth. We could have gone to this via that other page that I showed you before, but I tend to go to AustLII. It's probably habit more than anything else. And at the Commonwealth level, we look at Commonwealth Acts. Hopefully you're familiar with this by now. You should really know your way around this so that you know how to find these pieces of legislation. We go to EPBCA, and Section 3 provides some definitions, and it deals with the issue of an ecologically sustainable development. It describes the concept, provides a few examples, and this is one example of a definition in relation to ecologically sustainable development. When we get to it, eventually, you'll see that there are a number of key components, and these include some really important principles that flow down from international obligations. So we'll go to Section 3, which deals with the objects, and you'll see that the objects of the Act are A, protect the environment, B, promote ecologically sustainable development. So it's a really important principle. If we go to the state sphere, then we'll actually get a bit more guidance as to what we mean by this concept of ecologically sustainable development. And I'm going to take you to Section 8 of the Sustainable Planning Act, and that actually defines it. So Sustainable Planning Act, Section 8 gives us the meaning of ecological sustainable development, or ecological sustainability rather. Okay, now here's the important part. It is something that balances a number of factors. It's a really important principle. So bear in mind that ecological sustainability is where we balance protection of ecological process and natural systems, which is probably what most people would think about as the important thing in ecological sustainability. But it's not the only thing. It's one of three matters that must be balanced against the other two. The second one is economic development. And the third one is maintenance of cultural, economic, physical and social well-being of people and communities. So, you know, things that are to do with humans. So the ecological process is one thing, human economic development is another, and human culture, physical, social well-being of people is a third. All of that has to be balanced in the concept of ecological sustainability. So if you think about it, governments and councils, and I'm talking now Parliament, councils, the executive and courts all have to make decisions within the context of ecological sustainability where there is this balancing act. So, for example, if the state government approves the Carmichael mine, it does so considering ecological sustainability, weighing up the ecological processes, but also balancing that out against economic development and these other factors that relate to, I guess, human well-being, if I can say that. All right, so what are the key components of ecological sustainability? If we go back to our international law, you'll recall that the federal government commits itself to certain principles that relate to protection of the environment. And in the context of environmental ecology or ecologically sustainable development, there are a number of key components. There's the precautionary principle, there's intergenerational equity, there's conservation of biological diversity and ecological integrity, and there's the fourth one, improved valuation, pricing and incentive mechanisms. So each one of those four things, precautionary principle, intergenerational equity, conservation of biological diversity and ecological integrity, and improved valuation, pricing and incentive mechanisms, all of those things are components of environmental ecology or environmental ecologically sustainable development rather. Probably the most important one of those is the precautionary principle. You'll see that a lot, and it's important that you get your head around what's meant by the precautionary principle. In essence, it's pretty simple, and what it means is that in the context of making decisions and doing so having regard to ecological sustainable development, the precautionary principle says, look, if a party raises a threat of serious or irreversible environmental damage and there is scientific uncertainty as to whether there exists a likelihood of the damage, then that will trigger the precautionary principle. So if there's scientific uncertainty as to whether or not there will be this damage, and the damage we're talking about is serious or irreversible environmental damage, then the precautionary principle is triggered. Now, what happens when the precautionary principle is triggered? Well, the decision maker, once they make that assessment that it's triggered, the decision maker, whether it's the courts or the executive, will actually assume that there is a real threat of environmental harm, and will shift the burden back onto the developer, to the proponent, to show how the proposal or the application will mitigate that threat. So that reversal of the onus from the opponent to an application or a proposal to the applicant or the proponent is a really key element of the precautionary principle. And it's really important that you understand that. Once they do that, we then talk about the balance of probabilities. But it's up to the developer to get over that sort of 50% hurdle. Again, if there's any questions, use the chat facility or feel free to unmute your microphone and join us live. Okay, the next thing I want to do is share the screen again, because I want to show you something that I really think is fabulous in the context of learning planning and environment law. And it's this one here. We go to the Queensland Courts website and the eSearch Civil Files Trial Facility. It is great. So what we can do is a party search, and we can actually look at relevant documents. So let's key in here Fraser Coast. I've done that before. So Fraser Coast Regional Council. We're looking to search down here at the left-hand side any files that relate to the Fraser Coast Regional Council. And what I actually want to do is find the case of Fraser Coast Regional Council against Byrne Brothers. It's in the Planning and Environment Court. And not only does this tell me that there is such a case, we'll just pan down a bit, but really importantly, it gives me access to the original documentation. There it is, Byrne Brothers, in the District Court, which is the Planning and Environment Court. So you see here it says View File Details. Let's click on that, and we'll actually now see the documents that have been filed in these proceedings. And that's great in terms of providing you with precedents. So it has here the events that occurred under this tab. and then below that the actual source documents. And these are the actual documents that were filed. So you'll see here an application, which is a 2-page document. That shouldn't take too long to come up on the screen. So if you're looking for a precedent on how to draw an application in pending proceedings, what a great resource. Go into the eCourts search facility, and you'll see here, in this case, an application lodged by the respondent for certain things, and the basis of the application, and says, well, look, the respondent's not able to comply with a particular order of the court for various reasons, and asks for the court to make a ruling in relation to that. That's probably, I think that would be Section 601 application. So, but there's all sorts of things in here, and you'll see, for example, there is reference to an amendment to that order made by His Honour Judge Horniman Wren, and there it is. So that's the amended, sorry, it's an amended originating application I've clicked on, and it is here, Section 601 of the Sustainable Planning Act. So this is where the council brought an application seeking an order of the Planning and Environment Court for enforcement pursuant to Section 601 of the Sustainable Planning Act. And that enforcement is by way of restraint, if you like, by way of injunction against the respondent, which is Byrne Brothers, or its servants or agents, until such time as the respondent complies with conditions of a development permit for a material change of use for an extractive industry. So this is just an example of the sort of application that can be made. When it comes to the Planning and Environment Court, I mentioned that one application is perhaps to argue for or against an approval. It's a merits review, or the conditions of the approval. Another different, different type of application is for an enforcement order, and this is one of those enforcement order applications. And the great thing is that not only does it tell you the actual factual situation in the case, but it provides you with a great resource and a great precedent. And it also has, the affidavit. So here's a relatively short affidavit, and it will show you that in this instance, the particular solicitor swore that document and filed it. Okay, so I love that resource because it not only keeps you right up to date, but it also provides you with an opportunity to get some great precedents. Okay, if there are any questions about that, please let me know. But I'd encourage you to spend some time, just poke around there and see what cases are happening at various times. All right, well, we're getting pretty close to the end of tonight's session. Thank you very much for your patience. If you're viewing this after the event, please feel free to ask any questions through UCrew, and I'd like to see that being used more often as a facility. Now, this is problem number 4. We're going to talk about that tonight. We've got one answer there in relation to the problem that I set, which is a little disappointing. I'd like to see everyone in the class provide some commentary in relation to that discussion point, but there it is. All right, so in this particular case, we were asked to discuss, I'm sorry, I didn't even share the screen. So you're wondering what I'm talking about, looking at me rather than what I intended to do, which was to share the screen. So you can see that now. I've got the one response. So I'd encourage everyone to have a response for the problem set the week before. So this is last week's. We'll discuss it tonight. Okay, so there's the problem that we set. It was all about the problems facing the international community and devising and enforcing appropriate environmental laws. It really talks about the global dimension of international environmental policy and laws. I guess the question asks you to consider how developed nations can assist, in dealing with that divide between developed and developing nations. I guess it would require you to consider and reflect upon major treaties and deal with the sources of international law, customary law, general principles, etc. So and I'll add some commentary to that as well. Okay, well, I'll stop the share now. That's all I wanted to consider tonight. Unless there are any questions, any problems, any discussions about the assessment piece. The first assessment is looming, the 28th of April 2016. My recommendation is ignore that 28th of April deadline. Make it the 21st. Think about, okay, so we've got 2 weeks from tonight. I want to have it finished by then. That gives me a full week to maybe let it sit on the shelf for a day or two, come back, read it afresh. You'll pick up so many little issues that, maybe you missed out a word or maybe it doesn't read very well. So it gives you a really good opportunity to tidy it up and then submit it. Make sure you submit it on time. If you don't submit it on time, don't panic. You'll lose 5% per day, but do make sure that you get it in by Saturday week. So that's 9 days after the assessment is due, because after the Saturday week, that's the cut-off, you will get 0, and that virtually means you'll fail the course. So my recommendation is ignore the 28th, aim for the 21st, give yourself that week, and then upload it when you can by the 28th. Okay, if there are any questions, any problems, please ask that or contribute. If you find a link or you find something interesting, then add that to UCrew and we'll continue the discussions there. All right, thank you for joining us tonight. All the best and we'll see you soon. Bye.